Legal analyst Mpumelelo Zikalala joins us for a conversation on this. Mpumelelo, criminal trials, particularly murder trials, don't tend to last this long. It's been 4 years since the start of this trial. One of the delays, majorly so, was the change of the presiding judge of the trial, which was a significant delay because it means that everything had to start from scratch. But it's 4 years later since the start of the trial initially. Has it taken inordinately long?
Good afternoon to your viewers. Definitely it has. And it has to be one of the reasons being that you have to start the trial again over from scratch due to the change of the judge. Now, we have to blame them squarely in the hands of the court to say that it was the court that are meant to make sure that everything goes according to plan. We do understand that there are measures or things or circumstances beyond their control that needs to be adhered to. However, I think now they are moving at a rate in which is considered that is moving a bit faster. But generally, that's basically the rate in which criminal trials will go at.
Yeah. The evidence readiness and the evidence and witness readiness has also been a big matter in this trial. At some point, two various separate dockets were opened in the trial. That had caused delay. Reinvestigations and consolidation of evidence and witnesses had to be done. How much of this has just been sloppy litigation?
I would say maybe about 20% of it, but the rest is due to circumstances which is beyond their control. Where I would put the blame on maybe the prosecution is in instances where a witness is not available. A witness is not available to give evidence. That is something that we must blame solely upon the prosecution to say, at the end of the day, you need to make sure that your witnesses are present. You need to make sure that you're able to proceed. If that's not the case, then the presiding officer is about to take over as a person who's guarding against all these processes to then say, how do we make sure a curtail against that? When it comes to the sloppiness of maybe the investigation from the side of the law enforcement agencies, I think that's where the rest of the 6 years would that have to come into to say it has taken 6 years or plus minus too close to a decade as we are commemorating today for the matter to get into court. That will be all solely on the feet of the investigating officers to say how we are investigating this matter. Why do we have two dockets? If you have two dockets, that means you have two sets of accused. What's the strategy in terms of you prosecuting them, and why are you leaving others and only attaching just a few? I think that's maybe some of the things that we need to answer to.
Yeah, and so there were a lot of deviations and sidebar matters that had to be dealt with, which on a procedural and technical level were important, that took away time from the substantive arguments around this. One of the substantive arguments was the ballistics report and evidence thereto, which was brought into great disrepute, and the credibility of the ballistics experts were questioned at some point during the trial. How reliant is the court on evidence witness, especially when various expert evidences witnesses present evidence, and oftentimes when there's a dispute between the two of those, how does the court adjudicate it, especially if it's between duly qualified ballistics experts?
Well, the court is guided by the principles of saying, let's look at who is presenting the evidence. One, the credibility of that particular expert. Is it a person who's well vested in the subject, which is someone who's just, for a lack of a better word, just winging it? Then secondly, is the probabilities of what that expert is saying apply to the facts of the case? Then says, how true is this? How probable is it? Can I be able to attach a bit of weight as a presiding officer on what the expert witness is saying? But I'll only assess that at the end, once I've gotten all the pieces of the puzzle together, and I'm able to make sure that they are speaking to one another. So it was important that they go through that particular process so that you're able to evaluate it at the end. So the evaluation of that evidence or the credibility of it is still going to be done at the end, but it needed all those essential elements to be grouped together so that when you do a particular evaluation, you don't find yourself short, or maybe asking yourself or saying, maybe I should have asked this particular question to this particular expert. But the onus is still on the person who's producing it to say, if you are going to present someone or a witness as an expert witness, you must also cover the basis for their credibility and cover the basis for what they are going to come and say in the court, and how is it going to help your case in the long run.
For better or for worse, this case has been trialed in the media as much as it's been trialed in the court. And this is due to the great public interest and interest to the public that it has had over the last 10 years. Has that contaminated the credibility of the process?
I would say not necessarily so, because the legal experts that are there, by that I mean the legal practitioner and also the presiding officer, they are not going to use what the media is saying in order to assess whether there is a case or not and whether the individuals are guilty or not. They are simply going to go back to what the case law says, to what the law says in terms of legislation and common law, and apply those so that they're able to find to show a certain credibility. But I wouldn't say that it didn't have an impact in the manner in which they present themselves in court, maybe to the self-confidence of the legal practitioner and even the presiding officer, and the manner in which they would have handled certain situations that have taken place. So even though it is not that significant factor that there is, but it is a factor nonetheless that would need to be considered when one is considering the guiltiness or the innocence of the parties.